not entirely sure you have a copy of the same.
Why not?
I seem to have extras from the one that I have.
What does filing mean, Mr. Deputy?
If you do, I'll proceed, Your Honor.
You say, what does filing mean? I'm also surprised that you don't give me a copy. I'm looking at the player affidavit without an affidavit.
The owner that affidavit has already been filed properly for the court, so probably the best thing is to ignore it.
What happened with
Exactly my point, Your Honor. We did give copies to the registry. For some reason, I still hold on to at least one more that I hoped that I would be in possession with. I cannot explain what happened. I'm sorry for that. But it was filed. The dates and stamps are on the document. In fact, so much so that the applicant has responded to it. That through this affidavit, we set out the reasons why we are opposed to the accused person being admitted to bail. And Your Honor, I kindly invite you to consider this affidavit in total, but particularly spend a bit of time, Your Honor, on paragraphs 3 all the way to paragraph 12 of this affidavit. Your Honor, having the benefit of this affidavit and equally the benefit of the replying affidavit filed by the accused person through her counsel, Your Honor, the first thing that will become manifestly clear to you is that at no point in the replying affidavit does the accused person give any clarity or controvert the contents of the affidavit in opposition. At no point. Your Honor, the state is telling you at paragraph 4 that money was transferred from South Africa to Kenya and giving you two platforms through which it was transferred. There is no response to that. You're not paragraph 5, we're telling you there is an individual who is being sought, 5 and 6, in relation to who physically presented himself at the bank. There is no response to that in the reply of those. Paragraph 5 and 6. The initial one, Your Honor, was paragraph 4, that addresses itself to money being transferred from South Africa to Kenya. Then after that, I addressed you on 5 and 6 combined. Your Honor, paragraph 7, we are equally informing the court that in 5 and 6, yeah, very well. Your Honor, 5 and 6, we say that there is an individual who remains at large who, subject to confirmation, presented himself at the DTB Bank and Branch in Eastleigh. In their response, there is no mention of that. Your Honor, paragraph 8 is admitted to a fair extent that she is a branch manager. That is not in dispute. But we equally are telling the court that she holds a position of influence and therefore can likely interfere with the witnesses from the very bank who remains people under inquiry. No response to that in the reply affidavit. And Your Honor, the totality of it is that as opposed to favoring the court and perhaps to some extent the state with what their reply might have been, what the applicant has done, Your Honor, is to proceed and table her version of events with regard to her innocence or guilt in the replying affidavit. I would argue, Your Honor, that they've actually skipped this particular address and gone to the hearing because that is what they are telling you. Your Honor, you have been invited by my learned senior to look at paragraph 12 all through 18 of that affidavit in reply, and you will find, Your Honor, it speaks to nothing but the innocence or guilt of the accused person. But I need not remind the court, Your Honor, that this particular application is for the granting or denial of bail, so I shall stick to my limit. Your Honor, it is quite law that the granting of bail is not an absolute right. Courts have pronounced themselves severally on the issue. Your Honor, out of the many decisions out there, I wish to present to you the case of Jokton Mayende and 3 others.
Your Honor, I wish to object to this authority being put it up. Not being given the authority, and I have no right of it.
Your Honor, insofar as that limitation is concerned, Your Honor, the judge pronounced himself and reminded us that if there are compelling reasons, then an accused person will not be released on bond. Your Honor, if you flip a few pages ahead and look at page 5, paragraph 22, and again the learned judge says, allow me to read, all that the law requires is that there is interference in the sense of influencing or compromising or inducing or terrifying or doing such other acts to a witness with the aim that the witness will not give evidence or will give particular evidence or in a particular manner. Interference with witnesses covers a wide range. It can be immediately on commission of the offense, during investigations, at the inception of the criminal charge in court, or during the trial. And it can be committed by any person, including the accused person, witnesses, or other persons. The descriptors of the kind of acts which amount to interference with witnesses are varied and numerous, but it is the court which decides in the circumstances of each case if the interference is aimed at impeding or perverting the course of justice. And if it is so found, it is a justifiable reason to limit the right to the liberty of the accused. DTB being Diamond Trust Bank. The accused person holds a position of influence at the bank. She exercises control over her staff. And we are equally saying, Your Honor, as we speak, those staff are still the subject of inquiry in relation to these particular charges that we prefer. And therefore it is our claim that she holds, or she is in a position to interfere with witnesses. Your Honor, in the case of Mohammed Abdi Ali, the second of the two that I've given you, and the defense, and another versus the state, Your Honor, at page 3, which argues.
My next friend is not understanding what I'm trying to say. I'm trying to say that they are hinging on investigations ongoing. And we are saying there could be no investigation in relation to the accused person because she is not a service provider. She is not Safaricom. So if there's any investigation, it is with regard to Safaricom, as opposed to Diamond Trust versus the money. And that has been explained at page 13 of the supplementary affidavit, how the transaction of M-Tata is done. We are merely saying that there cannot be any further investigation in view of the explanations which have been offered. Your Honor, there's the National Payment System Regulations and Act. National Payment System Regulations and Act, which regulates M-Pesa transactions. And this explained as I refer to the affidavit in the replying affidavit. Act number 39 of 2011. It tasks Safaricom with vetting and carrying out due diligence and suitability assessment of M-Pesa agents. And further ensures compliance with the proceeds of crime and Anti-Money Laundering Act 2009. There's no obligation on the applicant.
John, I'm sorry, and I again will approach you with the same argument. From an objective perspective, even if I step out of the shoes of a prosecutor for this particular address, how do those submissions inform or affect your mind on whether or not you grant bail or bond? Counsel is arguing the merits of the case for or against his client.
Your Honor, the objection of the prosecution is that accused person should be released because investigations are going on. And we are saying that investigations are complete so far as the 3 charges preferred against the accused person is concerned.
Well, I think that will be sufficient.
Yes, and we are further saying that
that will be sufficient rather than going into explanations of how this.
Yes. Otherwise, we are also saying that the applicant has heavy family obligations. She's a widow. She has 2 school-going children. Whom she has not been able to attend to for the last 30 years. She has no capacity to interfere with investigations because the records are held as a record. And as a records are held as a record. The TV footage has already been taken by the investigative team. So that whatever the prosecution is looking for is beyond her reach. Your Honor, in a democratic society, in a constitutional democracy, it is the court that guards the liberty of the individual against infringement by the executive. We have come before you so that you become an arbiter in this context. In your legal arbitration, have regard to the legal rights. If it was for the state, nobody can be even bailed in a court in this country. Because they keep on enforcing on the flimsiest of grounds. Discount their reasons on the ground that person bails on cash bail on bail of time.
Thank you, Your Honor. Your Honor, the state is opposed to the accused person being admitted to bail or bond at this time. Your Honor, and in so doing, we shall place reliance on an affidavit informed by one inspector of police.
It's automatic that it will be granted bail unless there are contingent reasons. Constitution is saying is that investigations are ongoing. That's the main reason why there was a bail. There's no indication or evidence that this person wanted to plead the institution of the court. And therefore, there was no need to arrest the accused person if the investigations were not complete. After arresting the accused person, they have held the accused for 30 days in custody. They submit that it's sufficient time for investigations to be complete, having regard the 3 counts has now been filed against the institution.
Repeat that again, after that, after the arrested her, they have made a
Yes. And we submit that that is sufficient time for investigations to be complete, having regard to the fact that there are only 3 counts. Count 1, failing to report suspicious transaction. That is a complete offense. There's nothing to investigate. Either she reported or she did not. That does require further investigation really. Count 2, aiding and abetting commission of a terrorist attack. By failing to report suspicious transaction. Either she failed or she did report. It's another complete offense. This does not require further investigations. Count 3, failure to report cash transaction carried out of the bank. Again, that is a complete offense. Either she reported or she failed. Does not require further investigations. The accused person through the bank has supplied all the documents that will be required in investigations. And this is manifest from page 12